Hello, so welcome to our November 2025 breakfast briefing, the best bits, as we like to say. So we delivered that earlier on today, and we thought we'd just catch you up with some of our key topics. So I'm Louise, one of the pensions litigators.
I'm Ruth, the pensions partner.
I'm Freya, associate in the pensions team.
And I'm Sarah, a senior associate in the pensions team.
Brilliant. So you're probably all sick of the words Virgin Media, but that is where we began the seminar, isn't it? So let's kick off with that.
Yes, and hopefully this will be one of the last times we actually need to talk about Virgin Media, because it's not quite hot off the press news, but the government has introduced amendments into the pension schemes bill, which is hopefully going to solve the problem for people. For those of you who don't remember, and I'm sure everybody's all over this Virgin Media issue, Virgin Media, if you're a contracted out scheme between 1997 and 2013, you had to have an actuarial certification for your amendments. If you didn't have one, Virgin Media said your amendments were void. Oops, lots of schemes couldn't find the necessary actuarial confirmation. So that's why we needed a solution from the government. So, as I say, the government has introduced amendments into the pension schemes bill, and in a nutshell, it allows trustees to ask the current scheme actuary to bless the amendments which don't have the necessary confirmation. So basically, looking at it today, would there be a problem? Yes or no? And certainly speaking to quite a lot of actuaries recently, most of them are hoping that this should not be a difficult test to satisfy.
Yeah, that was the feeling, wasn't it, today? Generally, people were saying, the actuaries in the room certainly were thinking this is probably not that big a deal. One comment was raised, wasn't it, about perhaps if there's been changes in the earnings definition over that time, might be a potential wrinkle. You were saying, Ruth, that you can kind of look the current draft, say, where you can look now and see whether it would have been a problem or whether it would have passed the test back then. And it was interesting, wasn't it? One of the comments was, do you have to?
Yes.
Yes. Do you have to use hindsight? And I think the answer is, well, we'll see when it gets published. But the answer seems to be, it's whatever's reasonable. So you don't have to look through today's lens. You can just kind of look at the time.
Yeah, and I think there's going to be obviously some guidance for actuaries to help them with these tests. But I think it's basically really good news for pension schemes. There'll obviously be cases where things will need to be looked at a bit more closely, because as we always know, the devil is in the detail. But I think at a high level, this is absolutely fantastic news.
Yeah, I'd agree. And I think just one of the points to flag, there's the Verity Trustees case, which was heard by the High Court earlier this year. And I think we were saying this morning it's the longest pensions case to have gone before the High Court, 30 days or something.
Yeah, longest, most amount of court days for pensions.
So that decision has various points relevant to Virgin Media, or expecting that decision to have various points relevant to Virgin Media in it. So it's a watch this space on that one. And also the proposed amendments are still draft, so we'll watch out for the detail of those.
And I think the final point to note is, if you're a scheme which is already wound up, when the amendments come through into force, you won't need to worry about Virgin Media. And that's a real big tick in the box for people. Obviously, if you're in the process of winding up, you'll need to think about it. But those historic cases, the box is sealed.
For now. No, we hope this is it. So that's probably Virgin Media. Hopefully, the last time we'll talk about Virgin Media, pending the Verity Trustees decision. So, but sticking with the government and what it's been up to, we've got the pension schemes bill in relation to the surplus payments, which we also discussed this morning.
We did. So the government's introducing powers under the pension schemes bill to allow the easier release of surplus payments from ongoing DB schemes. So essentially, the changes introduced by the pension schemes bill are trying to make it easier generally for schemes to qualify, and also lower the bar. So essentially lower the bar from being funded on a buyout basis to being that test being on the low dependency basis instead. Ultimately, as we've always said and said throughout, the details are going to be in the regulations that now come out in 2027, but it seems on the whole that they're trying to make that test easy to get into for schemes.
Yeah, and this was one that we talked about this morning on what this means for DB scheme trustees and employers. Well, the regime won't come in until 2027 is the earliest we're expecting it, and the comment was made this morning that somebody will be amazed if the legislation's all in form, and it does actually come in 2027, but we will see. There was discussion about DB scheme trustees and employers needing to consider the extent to which they can and indeed they wish to take advantage of this relaxation of surplus requirements, and how what the regulator guidance might say. There was discussion about how, if schemes are going to have to consider this and potentially have a policy in place for surplus extraction, what this will mean and how this will work between trustees and employers. And the comments, there was comment made that this almost seems to be a bit of a backward step. We're only just getting on top of the contribution holidays that schemes took 20 odd years ago, and schemes are now getting back to a fully funded basis. In 20 years' time, will people following us be dealing with the ramifications of these potential surplus requirements? And then other points were made as to, could trustees be criticised if they went for buyout rather than deciding to run the scheme on? Because if they ran the scheme on, might there then be surplus for members to take advantage of?
Yeah, that was interesting.
Yeah, I thought that was a really interesting
There's a lot
point.
of chat about, or debate about, is this a risk-free, is there such thing as a risk-free option for trustees? But if there is this, the buyout, is that it anymore? Does this kind of throw that open? And I thought that was quite interesting. And there were mixed views, I think.
There were very mixed views, yeah.
And especially as there's other consolidators coming into the market alongside Clara. So more options, more choice, more challenge.
Yeah, clearly.
There's choice, there are options to challenge the choice.
Yes, and will it make things tricky between employers and trustees? Because it's a bit of contention as to who has the surplus, who it belongs to, and if members get what they promised, is that enough?
Yeah, there was a lot of discussion about that, about the potential of conflict of interest, and actually in situations where trustee and employer are working quite harmoniously together, but there probably would be, because they're trying to make sure that those protections are in place. But actually, as you've just said, I think it's going to go the other way, and there was a lot of chat about that, wasn't there, about the potential conflict of interest and strengthen the employer covenant if you do decide to go down this route. And interesting.
Members have strong views on surplus. We've got a scheme, it's a buyout situation, so it is different from this, but there are proposals to return surplus to the employer, and you need to write to members, communicate with them. And we had a good number of responses from members airing their views on what should happen with the surplus. So you sort of think, where will this go if it's an ongoing basis?
One thing that was interesting is that maybe we shouldn't even be talking about this thing called surplus, given that one of the views today was there is no such thing as surplus, because it can change overnight. From factors outside the control of anyone involved, but the position can change overnight, and what protections are there in place?
I suppose it's interesting moving it from the buyout level of funding to low dependency, because you may have a surplus calculated by your actuary on the low dependency basis, but you may have a deficit on the buyout basis.
And that was a
very
live
question.
wasn't it? That there's perhaps some pressure from corporate advisors to sort of trustees and trustee advisors as to the basis for calculation, because they might have a vested interest in there being a surplus.
Indeed.
Watch this space, definitely.
Well, it says, well, on the subject of pension schemes bill, we then moved on to just quite a discrete topic, but one for more for me as a litigator, in relation to overpayments. So, as most people probably know, but we had a quick recap of this morning, didn't we? So with overpayments, it's an odd situation in terms of how you, as a trustee, obviously you've got a duty to make sure people get the right benefits, and if it does go wrong, you've got a duty to fix it, and that includes overpayments broadly. But with overpayments, of course, if you get, for example, an ombudsman determination says yes, you are entitled to recoupment, so recoup the monies X amount over X period. That in itself isn't an enforceable document, because under pensions legislation as currently is, of course, you have to have an order from a competent court, and for those purposes, in that situation, the ombudsman determination is not an order, which I suppose technically isn't. It's a determination of an ombudsman, so it's not an order of a competent court for the purpose of then enforcing. So then you have to come to someone like me to then help you go through the court, go to the court, essentially turn that into an order, so get an order for judgment based on the determination. And there was some confusion, I think, in the room about what that means, because currently, if you have the right to something under a determination, if everyone plays ball, that's fine. But if they don't, you've obviously then got to enforce it at the court anyway, and turn that into go through the enforcement proceedings. The difference is if it's an overpayment recoupment process, you've got this third or this second of three process where you've got to turn the determination into something you can then hit the member with, if you like. Then try that. If that doesn't work, you've then got to go down the enforcement route. So it's a welcome change, I think, which is good. Moving on then. So we then looked at regulator interventions.
Yes, and there's been some movement on these, and several issues have been keeping the regulator busy. We have had another moral hazard case relating to the Edinburgh Woolen Mill. So the Edinburgh Woolen Mill collapsed during the COVID-19 pandemic, and administrators were appointed in November 2020. The DB scheme at that time was underfunded and entered a PPF assessment period. And the regulator became interested in this. It was concerned because there seemed to be rapid insolvency for Edinburgh Woolen Mill, and it occurred after a history of profitability. The regulator issued several statutory notices requiring financial information to be provided about Edinburgh Woolen Mill and the wider group. And this information disclosed details about corporate transactions prior to the administration, including intergroup loans and large dividend payments to the owner. So Edinburgh Woolen Mill was acquired by PurePay Retail Limited in December 2020, and then there were negotiations between PurePay, the trustees, the regulator and the PPF, and a scheme rescue was ultimately agreed that took effect in December last year. And this meant that the regulator's potential use of its anti-avoidance powers was avoided. And under the terms of the rescue deal, PurePay became the scheme's statutory employer. There was a scheme apportionment arrangement, and it paid 7 million to the scheme. This meant the scheme left the PPF assessment period. A recovery plan was agreed ending March 2028, and that was the technical provision set at a prudent level. And then there were certain covenant protections put in place on an ongoing and an insolvency basis. And according to the regulator, the scheme is now funded above the PPF funding level, and it's expected to achieve full funding on a low dependency basis within 3 to 4 years. So the regulator welcomed the positive outcome for scheme members, noting that it's vital that sponsoring employers keep scheme trustees fully up to date, which reminded us of the case that you've been involved in recently.
It does, because you would think that in today's defined benefit world, employers and trustees would be all over these risks. But we saw a case recently where we were brought in a very tangential way, and then said, what about the DB scheme, at the point where the pensions regulator was issuing lots of statutory notices for information, because surprise, surprise, there was an underfunded DB pension which had not been dealt with as part of a transaction. And we're very much at the early stages of the regulator investigation, because of course it needs to gather loads of information, which is why actually with Edinburgh Woolen Mill it's taken like 5 years for resolution, because they need to investigate and sort it all out. But it just shows from the experience that we've had to date with this particular instance, they're all over it, and they are seeking lots and lots of detailed information from everybody, whether you're likely to be in the scope of actually the regulator's beady little eye for powers or not. So the key thing is, yes, do talk to your trustees, employer, and employer, do think about the fact you've got an underfunded DB scheme, otherwise you're going to find yourself in trouble.
Yeah. And then there's a different one, isn't there, Freya?
There is indeed. So moving from defined benefit pension schemes over to master trusts, we did discuss now pensions. So unfortunately now pensions been the subject of regulatory intervention reports. The most recent one in July 2025, but there was a previous one in 2017, which was about the failure to monitor employer communication contributions. More recently, we've seen 3 different instances of communication failures. These were dating back to 2018, but in each of those 3 instances, we saw in the region of around 20 to 30,000 communication failures. What was really interesting in this circumstance is essentially both now pensioners and now trustees decided not to report this incident to the regulator as either a significant offence or a breach of law. And I think we had a bit of a discussion during the talk today, and we don't want to necessarily second guess, we weren't in the room when these decisions were made, but it does seem slightly surprising to us that when we've had previous cases where we've discussed with trustees whether or not it's appropriate to submit a breach of law report, these situations are considered in great detail and in great depth, and it's a somewhat surprising conclusion which they came to. Evidently, the regulator clearly agreed, because ultimately these financial penalties were issued.
Especially in circumstances where, in the first breach, for example, 30,000 failed communications. Yes, it seemingly was a part of one issue, and no reply, not email mailbox not receiving the bounce backs or not processing them. But I think just nearly 10,000 of those, nearly a third of those were mandatory communications. So when you're thinking about reporting breach of the law, there's a difference between obviously mandatory and routine. Nice to have. And that you would have thought was a factor, and obviously the regulator agreed.
Yeah, absolutely.
Yes, and I mean the now pensions case is obviously quite a serious example of things going wrong, and the key learning points that governance is key. And trustees need to ensure appropriate steps are taken to address any governance failures in a timely fashion. There's another quick last topic that we talked about this morning, which was a regulatory intervention in relation to employer-related investment, which we don't see that often. And this one actually resulted in successful criminal prosecution, which again, you don't see that often. Fairly specific circumstances. It was the Worthington Employee Pension Top-Up Scheme, which was set up for long-serving employees to top up other pension benefits. The company, Marcus Worthington Company Limited, entered administration. It was a construction, civil engineering, property development company, and the scheme had 57 deferred members, so a reasonable number. Now, insolvency practitioners were appointed when the company entered administration, and they submitted a breach of law report to the regulator about suspected employer-related investments by the scheme's trustees. The regulators did some digging. The report issued by the insolvency breach of law report from the insolvency practitioners highlighted that between 2009 and 2016, the trustees loaned funds and later invested what equated to 99% of the scheme's investments or scheme's assets into employer-related investments, obviously way in excess of the 5% legislative limit. So the regulator did a lot of investigating and ultimately concluded that there was employer-related investment. There were 3 trustees that they investigated and the professional advisor to the scheme. The regulator initiated criminal proceedings against 2 of the trustees and the professional advisor. They dropped against 1 trustee and the professional advisor, that they didn't progress there, but one of the trustees pleaded guilty to making 5 prohibited loans and was given a 10-month prison sentence, suspended for 12 months, had to complete 150 hours of community service and pay £1,000 in prosecution costs. And then one of the other trustees, a different trustee, it went to the regulator's determinations panel, and they agreed that the trustee knew that there were illegal investments, and they determined that this trustee had to pay a total penalty of £29,000 for the breaches. Ultimately, all scheme funds were lost. An independent trustee has been appointed, and they may be able to pursue a claim with the Fraud Compensation Fund. But that's quite an interesting case that we don't see that often, but it shows what the regulator can do and that it will exercise its powers.
It's interesting that the determinations panel limited the 29,000. The other one, criminal.
Yeah, I thought that was interesting. £1,000.
But 10 years in prison, obviously, 10 years, 10 months.
10 months, yeah.
Suspended. It's just, I don't know, it's all very frightening stuff, isn't it? I think just the key, one of the things we talked about today, wasn't it, was just making sure, obviously, one would hope that you don't find yourself in these situations. Or on the end of advising these situations, but it's just worth being mindful, I think, isn't it? Just just making sure that your governance processes are all there, and if unsure, ask. Brilliant. Well, that brings us to the end. So watch out for our next breakfast briefing. The dates of that will be coming forward soon. And other than that, thank you for tuning in.